Hello, everybody. Oh my goodness. My friends are all here. Hello, Nana Laura. Hello, Barbie. Hello, Auntie M. I miss you so much. I'm so happy to see you. Hello, C-Rex. Oh, you're going to have fun tonight. Oh. Hello, Lisha Panette. Good to see you, honey. Hello, Mortimer Duke. Hello, Danielle Stock. I am so happy you made it. Hello, Spider-Man. Hey, look, Spider-Man, we match. Hello, Shane. Great to see you, honey. C.E. Oh my gosh, you're so amazing. Thank you. Hello, James Russell. Hello, Vina7. Oh my gosh, I'm so happy you're here. Whee! You know what that reminds me of? That reminds me of there's a car insurance commercial with this piggy, and he sticks his head outside of the car window holding on to a couple of those spinners. And he's going wee wee all through the car ride until the mom stops the car and she's like, Maxwell, get out. Oh, Yvonne McLaren, thank you so much. I love you. Hello, Tiana Miller. You guys. This is my happy place. You guys make me so happy. I am so glad to be here. It's Earl Grey's birthday. Yes. Yep. That little bundle of joy right there, that little fur ball up in that box. Yep. It's his birthday. His original birth grandma, sent me the cutest card. It was so sweet, and it had his baby picture on it. I almost cried. I might have a little. Hello, Patrick B. Whoops. Sorry. Oh my goodness. It jumped just as I went to click it. Hello. Oh my goodness. Yeah, he's 2 years old. I put a picture in the Discord and I put it up on the community page so everybody can see his adorable, sweet, just born self. It was just, it's heart melting. It really is. It's just, oh my goodness, the cutest thing ever. I loved it. I was so happy. Thank you so much, Sandra, for sending that to me. Also, I wanted to say just a giant thank you to a subscriber who, they've been amazing. They have sent me super chats outside of YouTube. YouTube takes 30%, and they have sent it to me on the down low. They don't want recognition, but I want them to know how much I appreciate them. And I want you all to know how great they are. And I'm not going to say their name. I'm not going to out them. But I am so grateful and so appreciative. So I just needed to say thank you. You know who you are. And everybody can just show love to everybody and pretend that it's them. We'll do it that way. Oh my goodness. I had a cat that lived to be 21 years old. Yeah, she was my baby. I loved her so much. All right, guys. We're going to start off. We're going to start off with something else. It's not super long. But a couple of my I don't want to say favorites, but a couple of judges that I really enjoyed, I've started seeing more of. And so I caught a couple of interesting things.
There's Mr. Turner.
Yes, this is Mr. Turner.
All right, we see Mr. Turner. Thank you.
No problem. All right, Mr. Turner.
And are we ready on Mr. Turner?
We are, Judge. Yes.
Okay. Calling case numbers 23000-623-01FH, 23001-434-01FH, 23003-872-01FH, and 24002-195-01FH. All four matters, people of the state of Michigan versus Ahmad Turner. Parties to your appearances.
Good morning, Judge Leslie Cooper, on behalf of the people, P30857. I just would correct the record that the 24 case is not part of this hearing today.
Oh,
That's accurate.
that is correct. Thank you. Because that is Mr. Johnson's matter, and this is a motion to withdraw. So thank you. And defense's appearance, please.
Good morning, Your Honor. Nancy Gasso with NDS, appearing on behalf of Mr. Turner on cases ending in 3872, 1434, and 0623, number 80549.
All right. Thank you. Mr. Turner, could you state your name for the record?
Ahmad Turner.
All right. Thank you. So we are here today on defense counsel's motion to withdraw. So you may begin whenever you're ready, Ms. Gasso.
That's correct, Judge. I did file a motion to withdraw from the case. I believe the court and the prosecutor's office is in receipt of that. Your Honor, there has been a material breakdown in the attorney-client relationship. And with that, I think it is in Mr. Turner's best interest that he be appointed a different counsel to further assist him and represent him in his matters.
Okay. All right. Mr. Turner, was there anything you wish to add or
Yes.
Okay.
The thing about it was that I was in here. I was supposed to have a court date over a month ago. My lawyer was out for emergency matters. My family was trying to get in contact with the lawyer office for over 30 days. They was going down to the building, coming to the courts. The courts was acting like they didn't know what was going on with my lawyer. It was going to the law firm, and the law firm didn't know what was going on with my lawyer. It was a plea deal that came on the record that they told my lawyer about, and my lawyer didn't remember it, but I don't have nothing but time, and my cognitive thinking is extremely high, and I don't forget anything. So once I brought it to my lawyer that they came to me with a year to 15 years to plead to the home invasion case and then drop all my cases, Only thing I was trying to explain to my lawyer is I have
And
10
Your Honor,
months. I have 10 months in.
I just don't want him to be discussing anything in regards to the allegations in the case and the home invasion
I'm not,
or
I'm not.
anything like that.
Okay,
Okay, I understand, Your Honor. I'm not. So they came to me with a year to 15 years, and I'm like, you know, I've never been to prison. I don't even have a felony on my record. Why I can't? Can we try to get a year in the county? I done did 10 months and probably more now. I've been in jail for 10
And Your Honor,
weeks.
if I may,
I've
I
been to
apologize. I think this is a discussion that he should be having with the attorney that will be appointed. As far as any negotiations on the current offer, I don't think that it's
I feel
in
like
his
that
best
offer
interest
should
to
have been
be
on.
discussing.
I feel like that offer should have been on record, because if the judge didn't know about this, that's wrong, because the judge have the higher powers to do what he want, and the judge is the one who's the boss. So I feel like.
okay, well, hold on then, Mr. Turner, let me ask you, do the people have the most updated offer?
The
that they-
last offer is 1 to 15 on the home invasion, dismissal of the remaining counts, all of them, all 3 remaining cases.
Okay, so that's now on the record, Mr. Turner. I do agree with Ms. Casti. I think it sounds like you would agree that there's been a breakdown in the communications. So what we're gonna go ahead and do is we're gonna appoint a new attorney. We actually already spoke to the office about that, Mr. Turner. So we told them, they asked that we just contact them after this hearing. And then they're gonna go ahead and appoint you new counsel. You'll still have Mr. Johnson representing you on the one additional matter. And what we can do, so Ms. Cooper, you're gonna need to share discovery with the new attorney. So do you think maybe 2 weeks?
At least 2 weeks out, that'd be fine, I think.
Okay. So we'll come back in 2 weeks, Mr. Turner. That way your new attorney will have an opportunity between now and then to review all the discovery. Hopefully to have a chance to meet with you. And then when we come back, we can discuss everything else moving forward. Thinking maybe September 20th might be a good day. That
That's a
gives
good
us
day for the
just
people, Joe.
over 2 weeks. Yes, Mr. Turner.
I'm not going to address the case, but can I address some medical issues to you, Your Honor? It's not. It'll be. I'll make it quick.
Okay. Yes.
I've been through emergency about 3 times. I got diagnosed with high blood pressure. My blood pressure been extremely high. It's if you subpoena my medical records, they do not give me my medicine right at all here. Like it's to the point every day I feel like I'm about to die. Every single day. You can subpoena an endocrinologist or anything to the court in my medical records every single day. They have violated my 4th Amendment, they have violated my 14th Amendment and my 8th Amendment. They know I have diabetes, they know it can kill me, and they do not come at the right time, and they miss a dose of my insulin every day. I take 5 shots of insulin every single day, Your Honor, every day. I know I'm gonna get out and win my cases, this next case. Like, and then my guidelines is gonna be probation, Your Honor. But I know this. I'm 100% sure. It's like I'm here and they killing me. They killing my body. I have an illness that attack all the organs in your body that kill you. I'm not gonna be able to watch my kids walk across the stage. By the time I get I just got diagnosed with high blood pressure. High blood pressure messes up your eyes too. I'm gonna be completely blind. I'm gonna be sick or ill. So I feel like, can you address my bond today or look into it or anything, Your Honor? Please, I've been locked up over 2 months. I understand. My trial was pushed from August 5th to November 4th. 2 weeks before trial, the prosecutor office switched prosecutors. 2 weeks before, the other prosecutor we had, Your Honor, never said nothing at all. When this new prosecutor come, now she want to say someone's not
I'm gonna
ready.
stop Mr. Turner because I think he's getting into things that are inappropriate and not in his best interest to be stating these things on the record. So if he wants to talk about his medical, he needs to stick to that. But I would advise Mr. Turner not to be discussing anything else.
Okay,
At
thank
this
you.
point, I'm going to ask the court to mark his file medical. If the court needs to contact medical staff at the jail or have someone contact the medical staff at the jail and find out if there is a problem, and have that addressed. And if there is an issue, we can come back before the court. But if the file is marked medical, and hopefully he will get the attention that he requires.
Well, we have previously discussed this issue many times with Mr. Turner,
many
and the
times.
court's well aware of Mr. Turner's severe diabetes. And it sounds like now a blood pressure issue. But when we did look into this previously, we did speak to the jail's medical staff, and they stated they're very aware of Mr. Turner and his medical situation. And at that point, I have to leave it in the medical professional's hands. I'm not a doctor, I'm not a nurse. I have to trust their judgment as they trust our judgment when it comes to legal matters. So, Mr. Turner, what I will invite is when you have your new counsel, if they would like to address bond, being that they will be newly appearing on your matter, will be welcome to hear that issue. But as of today, bond is not going to be modified. And we are going to grant defense's motion to withdraw in this matter. New counsel will be appointed, and we will return in just over 2 weeks on September 20th. So is there anything else before we conclude?
Not for the people.
No,
Nothing
thank
else to
you.
have. Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, Mr. Turner. We'll see you in a couple weeks, okay?
I'll see you then. Thank you. Have a
All
blessed
right.
day.
Thank you.
I do really hope he is getting the medical attention that he needs. It sounds like he may have possibly been exaggerating just a teensy bit, because the judge did say the jail is very well aware of his issues and they are addressing them. But his rant and his recitation of the amendments that they're violating, it was a bit much for me. Oh my gosh, Mortimer Duke, thank you. Thank you so much. I really, really appreciate that.
You too. Mr. Tolbert, if you'd like to step up. Calling case numbers 22-001-15402FH and 22-006-39701FC. Both matters, people of the state of Michigan versus Kon Tolbert. Parties, your appearances, please.
Good morning, Your Honor. Natea Scott for the people. P78816, and I'm on case number ending in 6397.
May it please the court, my name is Mark Brown. My P number is 39562. I'm here on behalf of Mr. Tolbert, who stands to my left. State your name, sir.
Christian Tolbert.
All right.
Excuse me, and Leslie Cooper appearing for the people on the case ending in 1154, P number 30857. That's all right.
Judge, for the record, Mr. Tolbert, I'm representing you in place instead of your attorney, Mr. Beganik. Is that with your permission?
Yes, sir.
Okay. And Judge, I believe we're here to address it's my understanding, to address the bond or bond conditions. Mr. Tolbert is on house arrest tether. He's been on that, my understanding, since March. So the better part of 6 months almost. Without any violations, he has the potential for employment, and he would like to do that. As I said, there's been no violations of his bond to my understanding. And so we're asking for the court to allow him to obtain employment.
Okay. All right, people's response.
Any change in mind, Your Honor, I would like to see potential, not just potential employment. If he needs hours to go and look for employment, the people are amenable to that. The people have no objection to him having legal gainful employment. And I expressed some contention with the employment because I've listened to certain calls that he's made. So I want to stress that it needs to be legal employment, and the people are not again, the people have no objection to him gaining legal employment, but just to give arbitrary hours for him to go and do whatever, the people are vehemently against that. I have not seen a DSU report even advocating for a change in the bond, so I would be interested in a DSU report. But if he has a potential interview or something like that, I would ask that he submit that in writing to the court and to the people to review that. And if he does gain employment, then the people would not have any objection to him going to work. But with just saying some arbitrary, I have nothing to go off of saying that he just needs to go and look for work and he doesn't have anything lined up. The reason that he has not had any violations because those ramifications have been in place. So of course he's not going to violate.
Well, people violate all the time when not supposed to, but at any rate, he has not. And I suppose that Mr. Tolbert could certainly provide documentation of potential employment to the court and the prosecutor. And can you do that? Yeah, you go ahead.
Can I speak?
Yes.
Okay, so our last court date, when we addressed this, the prosecution's, her response was, I need to show proof that I'm even seeking employment. And it's okay, but the only confusion with that was, okay, so I talked to Mr. Gunn, and I was trying to get court orders to go to my son's graduation and his birthday party. Okay, the first incident, we got the court order for my son's graduation. I attended it, went back home. It was never nothing else.
Okay.
My son's just had his 5th birthday on September 2nd, and I missed it. I tried to get within the court, something within the court within a week or two ahead of schedule, and Mr. Gunn told me like, well, it's going to be an issue right now. We got to, it takes time to get in court. To get in court, to get the work order and all this did anyway. So my confusion was if I'm looking for employment and I have to show proof that I'm even seeking a job or talking to this job, it's going to be within an interview. And we all know the process. It's going to be interview, then orientation, then I work.
I am so sorry.
I need to get to the interview in order for me to show you guys anything. I can send you anything, but if we're not gonna be able to get in courtroom to get the court order for me to go to this job, I'm gonna miss out on another job opportunity. That's
Okay.
my only issue.
So here's what I'm going to suggest, Mr. Tolbert, and then I'll allow the people to weigh in. But so obviously, if you get a job offer or hired for a job, you'll have hours. You'll be able to provide verification. I see what you're saying, though. You might not have something in writing if you're just going to an interview. They may call you and say, "Hey, we need you here," and you may not want to let them know, "Hey, I need a letter for the court," if you're trying to seek employment. So what I would ask, and Ms. Scott, please feel free to add your 2 cents. But if you call us and just let us know, hey, you can call the court and say, hey, I have an interview coming up next Thursday at 1 p.m. and Ms. Scott's informed of that, we can just give you like a 3-hour window that day.
Okay.
And then, like I said, if hopefully you get hired by one of the, those employers, then you'll have more paperwork that you can provide and verification. Does that make sense, Ms. Scott?
Yeah, and most of the times when you're applying for jobs, I don't know if he's applying online. If he's on house arrest, then I know he's not actually leaving unless he has a job by word of mouth and someone says, oh, well, we're hiring and we want to have you for an interview. If you're given an interview, they're typically going to give you a time frame in writing of when you should be at that interview. I believe not just saying, oh, I may have an interview. What I'm looking for is proof. So if you have an interview, you're going to have an interview. They should be able to provide you. You have an interview September 17th at 6 o'clock or 3 o'clock or whatever the time frame may be. Submit that send an email to the people. I have no problem stipulating to that.
Okay.
We will do that.
Okay. So yeah, maybe Mr. Tolbert, then if they are gonna request that you appear for an interview, maybe if you could you don't have to say why, but could you just put that in writing in an email? Just
Yes.
so I have it for my record.
Yes.
Maybe say something very generic like that.
Yes.
And then that way we can, you can, Mr. Gonick can provide it both to myself and to Ms. Scott.
Thank
Okay?
you.
Thank you very much, Judge. Thank
All
you,
right.
Ms. Scott.
All right. Was there anything else we wanted to address today?
Not that I'm aware of, Judge.
Okay. Anything on behalf of the
Probably
people?
remain the same.
Yes, the trial date is October 21st, I believe.
Yes, that is correct.
Okay.
Anything on behalf of you, Ms. Scott?
No, Your Honor.
Okay,
Thank you very much, Judge. Thank you.
you're very welcome. That'll conclude Mr. Tolbert's matters.
Thank you. Everyone have a good day.
You as well.
Thank you.
Calling case 19006633 -01 FH. People of the state of Michigan versus Kenneth Faithful. This case before the court today for a show cause hearing. Appearance for the record, please.
Good morning, Agent Wright for Probation Services.
Good morning, Your Honor. May it please the court, Kathy Murphy, P 51422 for Mr. Kenneth Faithful, who appears in the courtroom before you, as do I. Sir, please state your name for the record.
Kenneth Faithful.
Good morning, everyone, and especially to you, Mr. Faithful. I know you've been waiting quite a while. Thank you for your patience. So first, as a matter of housekeeping, this should have been scheduled as an arraignment for alleged violation of probation. And the allegations, Mr. Faithful, which were from August 14th of this year, are that you did not pay restitution in the amount of $2,770, nor had you executed a wage assignment for from two missed regularly scheduled payments, that you had not paid the crime victims assessment of $130, and that you had not paid state costs in the amount of $68. Those were the technical probation violation allegations. And it's also alleged that you committed the following non-technical probation violations, which were on June 15th of this year. It's alleged that you stole $185.55 in checks from patron number 8. And it also alleges that you were paid by the poker table dealer in error. I don't know if that means that there was a theft, and there was some money given to you that you shouldn't have had and did not return. Seems that that's the allegation. And those are all the allegations. Now, Mr. Faithful, you have right to a hearing on these allegations within 14 days. If the court finds that you did violate probation as described in one or more of the ways as described, the court can modify your probation, can make the terms more stringent, more strenuous. We can make we can dismiss the case. We can send you to a period of jail, or we could modify the terms altogether, and that's it. And I'm just looking to make sure that there aren't any more allegations here. This is written in a way that's kind of unfamiliar to me. So, Ms. Murphy, does
Yeah.
Mr. Faithful know whether he wants a hearing?
Well, Judge, I wanted to ask Agent Bryan if she knew whether the non-technical allegation has been dismissed. Mr. Faithful believes that it has.
Judge, I have no pending information as to whether any charges were pursued as a result of those allegations in the warrant. So I would only be addressing the allegations that he has not paid anything towards his court costs and fees.
With respect to the payment issue, Your Honor, Mr. Faithful is appealing his conviction,
Yes, I see that.
and his attorney has advised him not to pay the restitution. The brief was filed on behalf of Mr. Faithful. And the state has been given until October 1st to file its response. Leave has been granted to hear the matter. So with respect, and Your Honor, on top of that, Mr. Faithful, as a condition of probation, is not allowed to leave the state, but he works as a truck driver, so he's been unable to work. So not only has he been advised not to pay, he can't pay at the moment because he can't work. So I would ask the court to return to this matter at a later date if possible. And also I would ask the court to allow Mr. Faithful to, Ohio and what are you?
Chicago.
He needs to drive between Ohio and Chicago for his job, if the court would allow him to do that so that he can work.
So, what I'll do with respect to the.
And Judge,
the
I'm sorry, I'm so sorry. May I continue or do you want me? We noticed when we were looking at the Register of Actions, Mr. Faithful and I, that his probation term has been continued to January of 2026. He was sentenced in January of 23 to 18 months. So his probation would be set to expire later this month, but it was extended by somebody at some point to January of 2026.
Yes, it was extended by me.
Okay, Judge.
Okay, so I'm going to put this out for 6 months.
Thank you, Judge.
And what that will mean, Mr. Faithful, is
I'm pointing to the culprit.
oh, okay. What that would mean is hopefully the Court of Appeals will have resolved your case by then, and that'll give me more information so that I'll know whether a hearing is even necessary at that point. But you've been arraigned. Let's pick a hearing date. And while Madam Clerk is looking for a date, Ms. Wright, do you
Yes,
want to
sir.
be heard with, do you want to be heard with respect to Mr.
No, Judge, I wasn't aware that he was appealing the conviction. None of that was indicated in my records.
But do you want to be heard with respect to his request to be allowed to drive out of state?
Oh, no, Judge, I don't have any objection to allowing to drive out of state for employment purposes only.
Okay. Mr. Faithful, are you currently employed or laid off, or what's the situation?
The routes that my job have right now currently are not in Michigan, so I haven't worked in like 2 months.
Okay,
talking about
but you're still on the roll, right? You're still
Yes.
employed by, what's the name of the company?
Sons of Queens Trucking. Sons of Queens Trucking.
Sons of Queen
Yes, Queens.
with an S?
Yes, ma'am.
So Sons, SONS of Queens with an S?
Yes, ma'am.
Trucking. Do you know the address? What's the phone number?
I don't have it with me, so my phone, I didn't know I could bring my phone in.
Okay, well, this is what you'll need to do. You'll need to contact your agent. And your agent can submit an amended order for me to sign that would allow you to drive in and out of state. Your agent will know what to do, just contact your assigned agent. Do you know who that is?
Yes.
Okay,
Thank you, Judge.
all right, thank you.
Do we have
There's
a
nothing else
hearing
for our
date? Do we have a
record.
next date
Oh,
scheduled?
we don't have the hearing. What is it?
March 5th.
March 5th? Does that work for you, Mr. Faithful?
That's right.
Yes.
I have a question.
Yes.
Well, one thing. I got a call last week from a district attorney on the allegations at MGM. And she told me that the charges have been dropped.
Right, I said that to
So-
the judge,
Oh.
and the probation office doesn't know.
So
So
you need to confirm that.
yeah.
You'll forgive us if we won't take your word for it, Mr. Faithful. They'll confirm it, and if that's true, they'll get that information to me.
So regardless if that's dropped or not, the probation is still extended to the 2026.
Yeah, unless I see a reason to to reduce it. Right now, that's not before me. Okay. So we'll see you March 5th. And I'll probably hear from your agent before that with respect to the amended order. Okay. Any other questions?
Judge, is Agent Brian able to?
Agent Wright?
I'm so sorry, Agent Wright. I'm sorry, Agent Wright. Is Agent Wright able to make inquiries regarding the new allegations?
She's probably going to pass it on to his agent.
Okay,
That's correct, Judge.
Okay.
look how happy Agent Wright was to say that's correct, so that she didn't have to do the work.
Anything else for this record?
No, thank you, Your Honor.
All right, thank you. We're off the record.
Let's go outside and talk.
Okay.
Just-
See you then.
Okay.
Yes, ma'am.
Before Agent Wright leaves, could we go back on the record for 1 minute,
Sure.
please?
Okay, just a minute.
Like, we put our appearances on the record, I think.
We do. Okay, we're back on the record regarding 19663301 FH, People of State of Michigan versus Kenneth Willie Faithful.
Thank you so much, Your Honor, for letting us go back on the record. I just wanted to clarify my interpretation of the adjournment for 6 months so that Mr. Faithful can have his matter sorted out by the Court of Appeals. One of his issues is restitution, and we just wanted to clarify that the court is saying that it's okay that no restitution payments are going to be required during that period, since that's the issue that's being sorted out.
Yes,
Thank you, Your Honor. I just wanted to clarify that.
thank you.
Okay, so I'm just pausing it to talk for a moment so that anybody who suffered from YouTube's apparent freezing can hit the live button and catch up. So, yeah, and I am so sorry. I am so embarrassed by the technical difficulty. I unmuted so that I could talk, and just as I did that, the case finished exporting on the other computer, and when it does, it very loudly starts replaying itself. So, I am sorry to everyone whose cat I scared, ears I, blew the drums out of, startled, drinks that spilled. I am terribly sorry. So everybody go ahead and hit the button that says live and get yourselves caught up. And then we can continue. And after this one small brief hearing, which isn't, it's nothing too exciting, but after this, we can get on to the main event.
Teyla Golston?
Teyla Golston.
Teyla. Miss Golston, let's see. I don't know, plead guilty to. I think that's a mistake on this one. Did you talk to one of the attorneys?
Yes.
Okay, was there an offer?
It was a lady.
Yeah, okay. Well, did she tell you what the offer was?
Yes, she said, okay, so because she kind of confused me because she said instead of having it to show up as like retail or something, she said allowing an unlicensed driver.
Yeah, that's what I got on here. It doesn't make any sense.
I'm like, I wasn't driving, but that's just what she said. That was what the offer was. So I didn't know.
Okay, well, that's what I'm reading then. What how old are you?
25.
Oh, so I think you could still do it. Shoot. Change the statute too for I think I got another. When did you turn Just recently? When did you turn 25?
My birthday is actually this month on the 17th, so I'll be turning 26.
Okay, okay. Yeah, that's kind of a weird way to do it, quite honestly. I tell you what, I don't want to hold you up anymore. Let me pass that for just a minute. I'm gonna go talk to her, okay? Hold on.
Okay.
It's just a weird way to do it, quite frankly. Hold on, okay? All right. Miss Golston, are you there? Why don't you unmute for me there? I'm gonna let you talk to Miss Robbins again. We gotta somehow figure a way to do something and she's gonna talk to you. Maybe we work something out, okay? And that's a weird, I can't find a factual basis for what they want. So I'm gonna send you back to talk to her, okay? Just stay right there for me, all right?
Okay.
Let's get you back. Where are you here?
Okay, and she never returns. But what that last one was, they gave her a plea deal. The original charge was theft. And the plea deal was allowing an unauthorized driver to drive a motor vehicle. One of these things is not like the other. And the judge, he couldn't take that deal. Because you have to put on the record that you committed the crime. So they have to be at least equivalent or similar in some fashion. And it just wasn't going to work out. Yeah. Right. Just take it, run. Oh, thank you so much for coming and for all of the sweet, sweet words. Oh my gosh. You are just amazing, and I'm so grateful that you were able to stop by. I don't know. I don't know, but that one struck me. Okay, now I can plug in the external. Oh my gosh. It sucks that that all of these technical glitches keep happening. 'Cause the worst part is now I can't make replay crew minis out of all of the messed up files. Arg. So, oh well. We're having fun. Tonight is have a blast watching April mess up. And YouTube.
Okay, position number 3, Aeros Davis and Jamia Williamson. If I can have both of you raise your right hands, please. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
I do.
Okay. Okay, so Mr. Davis, I show that the last payment that we received was on July the 17th, and there's not been anything since then. What's going on?
I made a payment.
When did you make a payment?
I just made another payment yesterday.
And how much was that for?
For $600.
Oh, okay. Ms. Carson, are you able to see that yet?
I checked this morning and I didn't see anything else.
I got the screenshot. I can show you the screenshot.
Okay, now you know that for it to show up for child support, you have to make it in advance of the date. And I'm sure you haven't received anything. Have you received anything, Ms. Williamson, since that payment on July the 17th?
No.
No?
But she gonna get some
Okay.
soon though. I just told her that I sent that. She gonna get that.
Okay, but you made it sound like you had sent her more payments. So you only sent her the one payment that you just did yesterday, right?
Well, I thought it was a payment for August too. Yeah, I sent this. I thought I sent a payment for August too.
Well, yeah, you know, if you've made payments, you might need to pull out your receipts and check with child support, but we're still waiting to see the one that you made just yesterday. So if in fact that was for, you know, $600, then that would, you know, get you.
Can I send it to the total? Can I send it to Jamia?
No, you have to send it through child support.
No. Okay, I'll try not that, man.
I'm sorry.
I'm gonna send her the receipt.
Oh, you said, oh, the receipt. Okay.
Yes, ma'am.
Okay, but the money, the $600 you did pay through child support, right?
Yes, ma'am.
Okay. Okay, so what we're gonna do is reset your matter. You know, that gets you, you know, of course you have $5,844 in arrearages. So you know, this is taking care of this month of September and then the arrearages. So we do need to see, looks like it's about $250 in October.
Sorry, Your Honor, but the arrears should be taken care of once the income tax, you know, like not saying I'm depending on that, but they're gonna take my income tax. So that's gonna clear up the arrears. And I'm going forward paying monthly. So so she's not gonna have nothing to worry about that part.
Okay, well, you know, that's a long way away.
No. I was talking about for this year. They for this year.
But what I'm saying is that when they take the income tax, a lot of times it takes about 9 months for the parent to see it. So even if it was for this year, you know, she'll be lucky to see that by December. That's just that
But that's what I'm
process.
saying. She's gonna get money going forward every month. But what I'm saying is that the arrears, I'm just letting you know that the arrears by the time the arrears gonna be zero. So that's what I'm trying to tell you.
I understand that, but you know, to take care of a child, you do need money today. So we have to make sure that current support is going to be taken care of, and she has not received anything. You know, she received some well, I will say you have been paying every month. The amounts have not been what we need them to be, but you have
They're
been
going to
paying
get there,
every
George. You know what I'm saying? She know, like she know what we're gonna have going on. Like we're gonna get a better understanding. You know what I'm saying? I'm gonna help her out even more. Like outside.
Okay, well I mean, that's future. That's between the two of you. But once the court is involved, my role is to make sure that this money is being paid every month. So you do need to make a payment for October. And then I'm going to see you again November the 1st.
All right.
Okay, and at that time, I'm going to be looking at your past history to make sure that you paid to make sure that the $600 was actually received and that you made that payment for October. Okay?
All right.
Okay. Okay, you both are dismissed. Well, first of all, Ms. Williamson, but you know, because I haven't heard from you. And we can't actually see that $600. Do you trust that it has been made?
I mean, when I see it, I mean, I guess it'll come through Monday or Tuesday, so I'll know next week.
Okay. Okay. Okay, so if there is any kind of discrepancy in what you're saying right now, Mr. Davis, you better make sure you get that $600 in, because When I look at this case on November the 1st, and if I find that that $600 was fictitious, then it's not going to be very good for you. You understand?
All right.
Okay.
All right.
Okay, then, but I'm sure you're.
By the time it get to me, it won't be $600. It'll be some that goes to his other child's mother.
So it's going to get split.
Yes.
So how many other children are there, Mr. Davis?
I got 3 children in total.
And they're all on.
Yeah, but what I'm saying is that I'm like y'all want me so broke. I'm gonna go take her. I'm gonna go take her the money I got from my Georgia Power. I'm gonna go take her. I'm about to take her $200 right now. I'm about to go drop $200 off to her right now. So it won't be. I'm not gonna pay my Georgia Power. I'm gonna just go take $200 that I got to pay my Georgia Power, and I'm gonna go take that to her right now. So you can give me credit. I'm gonna take $200 to her right now. I already made the payment, do child support, and I'm gonna take her $200 right now.
Well, that's fine, but
so go ahead and put that on there
working?
too. Take note of that.
Are you working?
I'm gonna take her $200 right now.
Are you working?
Yes, ma'am. I told y'all I'm working.
And what kind of job do you get a W-2?
Ma'am, listen, ma'am. I gotta explain the same thing every time. What I said, I got a house arrest monitor, so I can't really get a W-2 job right now. So I'm working 1099 jobs right now. But what I'm saying is that ain't like what I'm saying is that I told you what's about to happen. I already paid $600. I'm about to go take her $200 over there in cash right now.
But do you understand that everything that you say there's no evidence for? So that's great.
You just said that you trying to
wait a minute, Mr. Davis. I'm the one talking now. Basically, what I'm seeing is $1,400 in arrearage. And honestly, that's not so. Wait a minute. I'm looking at the wrong one. No, $5,800 in arrearage in your case. So that means that this is a low child support amount. I don't know what the others are like, but this is low. So you don't have a good track record in order to tell me and explain to me about what you're doing and how great it is, because your past says it all. So I just want to make sure that you understand that when I see you on November the 1st, that everything that you say has to be accurate. That's great if you want to that's great if you want to use your Georgia Power, but it is still in the future. It is nothing that I can see now.
You're not
okay,
listening.
I'm done, Mr. Davis. That's
I
it.
know what I'm saying, because I can get credit. What I'm saying, I can get credit. What I'm saying is that I still pay a phone bill, but what I'm saying, I'm not even trying to account for none of that, man. Like you're making it seem like I'm just a deadbeat. I still pay a phone bill. I still pay a phone bill.
Mr. Davis, the fact of the matter is that we're here in court today, and I don't have any payments to show for you. I am not going to argue back and forth. But you did not make, you only made that payment because you had court today. Because obviously, if your intention was to pay, you would have paid it before yesterday. So I'm going to dismiss you before things get a little bit too heated here. And I will see you on November the 1st. And if you're going to make any payments, do not wait till the night before. You make them the week before your court hearing date, or I don't want to hear this anymore. You understand? Do you understand?
Ma'am, they muted me.
Okay, goodbye. Thank you, Miss Williamson.
Darn right they muted you. Oh, yeah, this judge doesn't play around. She wants those kids to get the money they need to, eat, have clothes, have the necessities for their education. Yeah, this is Georgia.
Mr. Berry and Miss Howard. Mr. Berry, I had asked before that you present the paperwork that you had regarding a matter that we were not able to conclude at the last hearing. Have you presented the paperwork? You are on mute, Mr. Berry. Please.
I'm sorry. The email address they keep telling me to use keep coming back not receivable. But I just asked the young lady that was with us the last time, do she want me to send it over to her? And she hasn't responded to me yet. So what's that? Miss Cross, I believe her name is?
No, I'm not familiar with that, but you can send it to.
What's
me, but I don't see any.
Crossing, attorney Crossing?
It's
Carson?
Carson. I don't
Yeah.
see any chat from you.
Okay, it says direct message.
Says
'Cause
you
when
never
I-
read the email to send the paperwork. That's all I see.
Okay, and then it says, do you want me to send it here? So let me do this. Hello. Let me know if you let me know if you got that hello.
Yeah, we can hear you, Mr. Berry, but.
No. I'm talking about I'm sending her a message right now on the chat. And I wanted to see if she got the hello.
Yes.
Okay, so do you want me to send that information through here? Because the email that they keep telling me to use keep coming back that I can't send through that email. So do you need me to attach the file here?
I'm typing it right now.
Okay.
Okay, I really can't move forward with anything until we see that paperwork. So I'm gonna just go ahead and make sure that you send that right now. I know, Ms. Howard, that you have time constraints, and we're just working things as quickly as we can. However, we are gonna go ahead and move to position number 2. Oh, and thank you, Ms. Ford, for putting everybody in the waiting room. Which is Christopher Burnett and Renata Foster.
So do you want me to get out of this and go to my emails and do it that way?
Ms. Carson, we only have him present, so you can go ahead and tell him what is needed from him.
Thank you. I sent him a chat. Just tell him to email it to me.
Okay, so do you want me to get out of this and then go to my emails or just drop this down?
Are you talking about your hearing? Just drop it down. You can pull up an email.
Okay.
Okay, but we've been waiting for that since the last hearing, so.
Well, again, the email that they kept telling me to use, they said is non-sendable. So yes, of course, you're still waiting for it. So now we're going to straighten it out right now. So what? All right, I'm gonna drop this down.
Okay, let's move to position number 2.
Your Honor, I emailed over the letter that Mr. Berry sent.
Mm-hmm.
I don't have an explanation for it, why they put in 256, but it's not a letter about reduction. It's a letter that they're required to send when they want to increase somebody's repayment amount. Before they go to court, they do different administrative things. One of the rights that they have is to send a letter out, and then the person has, I think it's 10 days, no, it says 14 days to object to the amount of increase on the repayment that they want to do. So what they said here is that they propose the back pay be paid at the rate of $91.20 per month. And then it says, in addition to the current support of $256. I have no idea where that $256.
So it says probably just an error then.
It's just an error, but all this letter is about is to increase his repay amount, which looks like they did because it now says $91.20.
Okay, so it basically just means that instead of well, that's the amount that's on mine. Yeah, $456 and $91.20.
So he apparently never objected from the time that they sent him this letter within those 14 days, which was almost a year ago. So they increase it.
Okay. Okay, so it's definitely not about a reduction.
No, and they wouldn't have the right to reduce it by a letter like this anyway.
Okay. And which court was it that did that?
His case is in Clayton, but this is an administrative letter that I don't know which office sent it. Maybe I can. The Morrow.
So if he has issues, should I send him to Clayton about the letter sent? Who should I?
Yeah, definitely. Yeah, he definitely needs to go and talk to them at Clayton.
Okay. Okay, I know Miss Howard has to get back to work, so Mr. Keys, can you bring back in Stephen Berry and Lakeisha Howard?
And I forwarded that letter over to Mr. Keys.
Okay. Okay, Mr. Berry and Miss Howard. We did have an opportunity to review the letter. It appears as if the letter was not about the current child support. It is about increasing of the amount of the arrearage. And it was just basically stating that Mr. Berry had 14 days to object to an increase of the arrearage, but because he did not, that arrearage has moved forward as an increase, and his current child support amount is $547.20. Apparently there was a typo as to the current support amount. I cannot tell you anything about that, Mr. Berry, other than to go to Clayton County about that typo, but the letter itself had nothing to do with current support. It only dealt with that increase in the arrearage amount.
Okay,
So,
well,
and
okay, go ahead. No, go ahead.
no, that's it.
Okay. So now I need to get I need to get in touch with Clayton County and see why this paper is falsified.
Yes, you can discuss whatever it is with Clayton County, but I just want to let you know for the purposes of this court, the child support amount is still the $456 and also a $91.20 amount towards the arrearage, because that is what we still show on our documents. Okay, so that is the amount that you are expected to pay. So the last payment that we received is for $298.59. That was for August. So can you tell us when you are going to get your amount increased for the amount that is owed?
Okay, let me ask this real quick. If I send 350, why is she only receiving that low amount? If I send $302, let's say $302, why is she not receiving even the 300? Why is it below the what I sent?
Well, I'm not aware of it being below what you sent. I'm only showing $298.59. Ms. Carson, is there any
Well, if he sent in for that August payment, if he sent in $300, then she got exactly what she should, because they deduct $1.50 for the Family Support Registry processing the payment.
Oh, well, I mean, I pay for all that when I send in the payment. So what else deduction is going out of that? So okay, let me get an understanding real quick, and then we can go. So say I do 300, then it comes out to be 320 after all y'all fees and everything. Then they're going to take another fee out of that 300?
Does any money go to your other case?
No.
Okay, I'll check on
And
that.
I don't think $2 will go to another case, or $5 will go to another case.
They only deduct $1.50 unless there is money owed to the state. They could deduct some for money that might be owed for the state, but I don't know that.
Okay.
But it's only $1.50.
Okay.
I'm looking to see if any of the money went to your other case. No, I don't see anything going to the other case. So if you send in 300, 298 is what she would receive.
Okay.
Okay, but I still didn't get an answer. You know, the child support amount right now is $547.20.
Yes, I understand that, and I'm going to call Clayton County, because I'm going off of the paper that they sent me, and you're saying that it was a typo, it was a mistake, this, that, and the third. So I need to clear that up. So now all of a sudden, now from $4 something, now I got to pay almost $600. So I need to clear that up.
Okay, so when is it that you intend on going to Clayton County?
Well, I'm gonna have to go Monday. I'm gonna have to go
Okay.
Monday or Tuesday.
Okay, good, because I just want to make sure that you clear it up or that they explain things to you promptly. So I am going to put you down for, let's see, October the 18th.
Okay.
Is going to be the next calendar. So I'm trying to give you enough time to get everything straightened out so that you know exactly what your obligations are with regards to this case. Okay, Miss Howard, I'm not sure whether you are there or not.
Yeah, I'm
there.
here.
Okay,
I'm here.
so
I'm like, I work at home, and my supervisor, I'm sneaking this, okay? So I just wanted to know what was going on. That's why my thing is down, because I got a call right now, and I got her on hold. But I'm just letting you know what I'm doing. Yeah, I'm here. I don't have any. I'm not saying nothing. He paying something, so I'm not saying anything. Whatever you want me to do, I just do, because I'm just trying to get this taken care of.
okay, then. And I hope you got the record that, we're going to see you again on the 18th.
Yes, ma'am.
October. Okay, so we will see you then, and we're going to keep on trying to make sure that your child gets this child support. You have a great weekend.
You too.
Okay. Thank you to both of you. Have a good weekend. Okay. Position number 5 is Frederick, Sharon, Hill, and Brena Harrison. Okay, Ms. Harrison, if you could turn on your camera.
I'm sorry. I'm leaving the patient's room. Give me one moment.
Okay, no problem.
Okay, sorry.
Okay. If both of you can raise your right hands, please. Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes.
Yes, ma'am.
And this is the one I think Auntie M is going to just lose her ever-loving mind over. And yes, his name is Ali.
Okay. Okay, so Mr. Hill, the last payment that we received in your case was for $46. And your child support amount is a low $310 a month. So can you tell me what's going on with this?
Of course. I actually pay 2 child supports. I have 2 cases.
Mm-hmm.
So I just acknowledged that when I pay for one case, they split it up.
Right.
So that's why it's showing.
Well, but honestly, if they're splitting it, neither of these payments, even if they were doubled, would be an adequate child support payment.
Yes, ma'am. I'm making payments at the beginning of the month and at the end. So I'm doing 150, 150.
Okay, so, and is that, so I mean, are you saying for each case, or are you saying $150 towards one case and $150 towards the other case? Is that
Prior to my acknowledgement, from that splitting up, that's when I just realized that they split it up. So I was doing 150 for Brenda case. That's one case. But now I have to make an adjustment to my approach to it. Because it was a recent acknowledgement.
okay? So, because if you have 2 children that, are entitled to support, you need to be supporting both of them. Is the child support amount in the other case similar to the 310?
No.
How much is that one?
Outrageous, 700 or something.
Mm-hmm. Okay. So you should be overjoyed that you have this one for 310. So, what are you going to do to get this up? Because this isn't going to work. $150 is not going to.
Yes, like I said, 150 at the beginning of the month and 150 at the end of the month. That was prior to my acknowledgement and of the DCSS splitting it up.
So now that I know they split
okay.
it up, yeah. So now that I know they split it up, I'm making arrangements to my approach to the payment.
Okay, so when you say your approach to the payment, are you going to pay more money?
Yes, ma'am.
Okay, and when do you foresee getting this started?
As soon as possible. Right now, I'm down to a car accident, but I just made a payment this week as well, and I'll make some more payments most likely next week to get it down.
Okay. So, what kind of job are you working at this point?
I'm a truck driver.
Okay, so are you independent or do you get a W-2? What kind of job is this?
Yes, W-2.
Okay, so what I want you to do is give your employer information to Attorney Carson in the chat. You can do a private chat to her, give her your employer information so that we can begin the process of an income deduction order.
An income deduction. So y'all plan on taking it out my check?
That's the way it's typically done, yes.
When did that start?
Well, first we have to get the information from your employer, and then we contact the employer and it gets set up through them. So it's hard for me to tell you exactly when, because your employer, depending on how big they are, they may have some paperwork process that they have to go through.
So for the paperwork, I signed because I agreed to making payments on my own. I didn't agree to y'all taking it out my check.
Well, and that's fine if you are making on your own, but you're not. So we need to move forward with an income deduction order.
Okay, can I say something?
Of course.
Yes, not to be rude or anything, but like I said, I am making payments. I just acknowledged that they split it up. I was making 150 for this case a month at the beginning, at the end. So that's what I'm just like trying to arrange right now. So like I said, next week I'll make those adjustments.
Okay, but now I just want to, clear something up. So we've been back and forth in court for how long? How many times have you been in this court?
Too many.
It's been over a year.
So you're telling me that, you just made this acknowledgement, but the child has gone without support.
No.
Ms. Harrison, how old is this child now?
He'll be 2 in November.
2 years old, and there has been no money through this court. I can't tell you what else you've done, but there has been no money other than a check for $8 earlier this month and the $46 that we just got.
So I'm making
we're already
payments.
up to $565 in arrearages.
So I'm making payments in 2 different counties, or how? I'm confused because I've been supporting and my family been supporting, and now
Don't lie under oath, Ali.
Okay, I mean, there's nothing really to say. You can't convince me that you've been paying support because the records speak for themselves. So I don't really want to go back and forth with that. We need to have consistent support. I'm sure
Yes,
Ms.
I understand
Harrison
that.
needs to get to work. I'm sure you need to either, get to work or do
Yes,
something else.
ma'am.
We don't need to be here. All we need is the support. We don't have to talk about anything.
Yes, ma'am. To my understanding, the child support just got established in August, correct?
That is correct.
Okay,
But
so
you've
now,
known about your child for a long time.
yes, and that's what y'all see. I've just started making payments on the child support.
You
So y'all have
don't
that.
lie under
Y'all
oath, Ali.
Okay, Miss Harrison, I got this. Okay.
Okay.
Thank you. Thank you. So yes, we've been supporting. He's been around. You can ask, I have receipts. I have
I don't know
all types of
what
things.
Mr. Hill, what?
I have receipts for support.
Okay, but that doesn't mean anything to me on,
You asking
you
for
know,
support, right?
yes, but
I
on
have
August
receipts.
1st, you knew how much your child support obligation was.
I
And
also
I'm
have
sure
a,
you knew how much your obligation was to the other child.
yes, and that's
So
the one that's
yeah,
killing me.
so when you paid this one, we take every child seriously. You know, you should have been already paying the other one. So you
Yes.
can't tell me that, you know, you're doing a great job of this. So
I
let's
never
just
said,
move.
I never
Okay,
said I'm
but
doing a
let's
great
just,
job, man.
okay, so let's just move forward because I don't want things to take a negative turn. So in moving forward, let's just go ahead and get your information to Miss Carson so that we can make sure that things go well moving forward. And I'm going to reset you for, oh goodness, let's see. I want to give a, okay, so let me do October the 18th is going to be the reset date.
That's what we
So
talking.
that we can make sure that we've got that information from your employer and we can start the process of getting that income deduction order set up. Okay?
Can I disagree to that?
You can disagree, but we need to move forward. Okay?
Yeah. I will, yes. Yeah, I disagree.
Okay, so when are you going to get that information into Miss Carson?
She can send me over her email or whatever she needs.
Okay, so she's available right now in the chat. Can you just go to the chat and do a direct message to her of your employer, name, address, that information? I'm sorry, go ahead, Ms. Carson.
Yeah, I sent him a chat and I also sent him my email, and I would suggest that next time you put some clothes on for court.
That would be very nice. Okay, you understand?
No, ma'am, I don't.
Well, I would like to think that you did because I don't want to see you in jail, but we'll see. Okay, thank you very much for your cooperation and have a good weekend.
So I'm making payments on my own, right?
You're going to start making payments through an income deduction order because you have not been making payments on your own. And I don't want to hear your explanation. I can only go by the records that I have. Now, if you want to begin making payments on your own, I will give you the opportunity to make those payments prior to that court hearing date on October the 18th. But just remember that in order for you to make those payments, you're going to have to take care of the obligation to your other child as well. So in order for Miss Harrison to get what she needs, then you're going to have to make a payment. And I can't tell you exactly what the other one is, but you're going to have to make a payment of over $1,000 a month. And that needs to be made current for September, and it needs to be current for October at the time that I see you on October the 18th. So that's the bargain, okay? And if we can't do that, then I definitely am going to need the income deduction order.
Understood.
Okay. And let me tell you again, that does not mark the end of our court hearing dates. After we see that you're current, then this case stays on my calendar for a few more months to ensure that you stay current. And after we see a period of time when there are satisfactory payments, you know, then this matter can be dismissed.
Yes, ma'am.
Your Honor,
Okay.
I sent him chats and I sent him an email. And just to clarify, when a case is open through the Department of Child Support Services, payments must come through an income deduction. You're not allowed to make them on your own. That may be fine for purposes of Judge Scott in this court, but it will not work with the DCSS case.
Well, And I'm not suggesting that because that's why I'm telling him it's gonna have to be over 1,000 because when he makes that payment, he can't make it directly to Miss Harrison because then of course the other parent doesn't get anything. It's gonna have to be over $1,000 so that it can split through DCS, DHS, and that way each parent gets what they're entitled to. Okay?
Yes, ma'am. I understand you. Thank you.
Okay, then. Okay, you have a great weekend. Thank you, Miss
Likewise.
Harrison.
Thank you.
Mhm. I'll tell you. Okay. Okay. I'm not sure if Miss Huffman appeared, but I do see Mr. Johnson. So, Mr.
Excuse
Johnson,
me,
if
Judge. Can you
yes,
hear me? I'm sorry. Miss Huffman, she called the clerk's office today and said she had a stomach virus, so she wasn't going to be appearing today.
really.
Yes,
Yeah,
ma'am.
this is going on for too long. So, Mr. Johnson, I have a question for you. Okay, so Miss Huffman has another excuse today, and I just wanted to find out, did you want to go ahead and do the arrest? No, I'm sorry, you are on mute.
Yes,
Okay.
move forward because I haven't received anything and I don't think I am without this arrest. So
Yeah,
it
and
is what it is.
it is. I mean, I've tried to work with her and this isn't working well. So I want to make sure that the children are the first priority here. So let me just go ahead and sign off. Do you know if you have already signed an arrest warrant?
I believe so. It was
Okay.
the initial one, but I can go down to the place and sign a new one.
Oh, no, we'll check. We'll follow up and just to make sure. We'll contact you if we need another one from you, but
It's been
we'll go
signed.
ahead. It has been signed. Okay, so I just need to sign it and we can move things forward. Okay,
Hey, Judge, but she did say she made a payment today of $200 and she's able to do it online. She said she made a payment today of $200. That's all I see on here.
well, that would be the largest payment ever if she did. Okay. Mr. Johnson, I'm gonna hold off for
It's
just a
not,
moment.
it's been a year and $200.
No, I believe me, I understand, but when a
I can
person
check.
makes,
Yeah.
oh, okay, let's see that.
I
When
can
when
check.
a person makes a payment, it does take it out of abandonment.
Nothing would show up and probably till next Tuesday, but I can make a note and contact the court and let you know whether a payment shows up. And then you can decide
Okay.
on the warrant or not.
Okay, so
So how
Mr.
this works
Johnson,
is anytime we go to court, she can make a payment of whatever amount and then it drops it out of abandonment.
I'm not gonna say whatever amount. It has to be, something adequate. I mean, and granted, even a $200 payment is really just about half, but it is progress for her. I mean, and ultimately, I'm not trying to put parents in jail because then your case moves to state court and
That's
what I
why
don't.
that's why I signed this in October of 2023 because I had not received a payment in 3 years and
Oh, no, understand,
I
I'm
just don't want
trying
my
to.
time to continue to be wasted because now we're prioritizing her other 2 children over my child and this is a year now.
The only reason that I say that is that once we get to the next phase, then part of the child support money starts going to probation fees and court
That's fine
fees.
because I'm getting nothing now. So at
Well,
this point,
I feel
I'm
bad
very
about it
over
because
it.
if there's any money to be had, I want it to go to the child. Now I do understand what you're saying, and I know I have been seeing you. I mean, I'm pretty sure it's been a year, but I just want you to be patient one more time because she's going to understand that if she didn't make that, first of all, if the payment does not show up at all for Tuesday, then the arrest order is a done deal. But I'm going to give her one more time to show up here in court, no excuses. And I just want to see if she is going to do what she needs to do. I've given her chances. I believe she's the one that keeps looking. Is she the one that's in Alabama that's trying
No,
to look for
yeah,
a
that's the
job in her
story.
field?
She lives in Georgia. She's been living here for 2 years, so
Okay.
it's the willfully not paying, and she's blatantly said that she's not going to pay it. So, and then we see it with the actions.
Right. Okay. Okay.
Yeah.
But I'm gonna reset you. I'm not gonna give her a lot of rope. I'm gonna just reset you to October the 18th, and that's it. Okay, so just be patient with me. One more time. She doesn't do what she's supposed to do. You know I'm capable of doing the arrest order because I was gonna do it today until I heard about some money. Okay?
Okay.
Okay. You have a good weekend, okay?
Thank you. You too.
Okay then. Bye-bye.
I understand his point. Who cares if the money goes to probation fees if he's not seeing it anyways? Yeah, deadbeat parents are the worst. She would have signed the arrest warrant if the mom had not dropped $200 payment down. But that's the thing, is they know how to play the system. They know how to work the system. They know all the little intricate rules to get away with it. And it sucks. It's terrible. They're horrible people for doing that. I'm glad that, some money might be going to the child. Maybe this time. But she's just going to sit it out for another, 90 days, however long she can, without doing anything, and then drop another small payment. Hello, Sobe Liz. All right, let's see what I got. I know I've got something about some cabins being burglarized.
Yeah. Ms. Norden, can you hear me?
Yes, I can.
Excellent, thank you. I believe with one of the counts, was it count one of the counts you wanted the court to consider doing a probationary sentence with a withheld sentence with a recommendation or an order that she comply with or apply to the Burnett County Drug Court. She's not a Burnett County resident if the court is recalling correctly that she is a Washburn County resident, so that would not even be applicable. Okay. I just wanted you to be aware of that fact. Only Burnett County residents can be in Burnett County Court. Only Washburn County residents can be in Washburn County Drug Court. Only Barron County residents can be in Barron County Drug Court. All right. Anything further before I render sentence?
Oh, yeah.
I have thoroughly reviewed all of the information and all of the filings in the court within the court file. And I sometimes do this and show, see, I take notes on all of the things. I take notes, I write things, I put my own little reflections on what I'm reading and how I'm reading it. I don't make any determination of what I'm going to do until the actual sentencing date and time, because quite honestly, it can be swayed and it can be changed, because I did have a recommendation from Department of Corrections with the 5 years of initial confinement, 5 to 7, and 3 to 4 with extended supervision. A lot of times the state, unless it's capped at a certain amount or provides a different recommendation, usually falls in line somewhere near a Department of Corrections recommendation, but sometimes they don't, as they did here today, argue for something completely different than what the Department of Corrections did recommend. And because, quite honestly, there are factors that come out through attorneys and through their arguments that I don't get to hear or see, even if in this pre-sentence investigation report. And Your attorney is a really good attorney, Ms. Mortenson. She's very prepared. She's very efficient at what she does. And as you can see, because from the start to the end, it's a very quick process, and that shows on your attorney, that shows on you and your willingness to help and cooperate. But she is also one of the few attorneys that really do a great job for sentencings, and more importantly, for serious sentencings with her sentencing memorandums and all of the information that she gathers and provides to the court, which things can change and things can be added in the arguments. That's why a court cannot make a decision as to what to do with regards to sentencing. We're dealing with very serious counts, burglaries, and it's a crime spree, so to speak. And it lasted from approximately November of 2023 until March of 2024, where numerous people were victimized. So it's quite serious. And Mr. Schmidt has stated this not only in this hearing, but in other hearings. And this is a fact that if you're a Burnett County resident or somewhere near there, you're aware of this fact that Burnett County is at a serious risk, if you live here, to be burglarized. We are a very high county with that regards, probably because we have so many cabins. This is a vacation retreat. This is where a lot of tourists come. And honestly, criminals think they can victimize and burglarize and get away with it because no one's here. And I don't know if that's why Burnett County was targeted in your criminal spree, in your crime spree, or what the reasoning was for hitting Burnett County. When I first looked at this case and looked at all of the charges, all of the burglaries, all of the additional bail jumps, and I calculated the potential that hangs over your head, you could have a sentence of 171 years of incarceration. And that's a mix between initial incarceration, actually serving that in the prison, and that extended supervision where you're on kind of like parole, but yet you can be sent back to prison. 171 years of incarceration hanging over your head. That is beyond a lifetime. That is 2 full lifetimes or more, depending on your genetics, your health, etc. From this deal and this agreement, and I understand the basis, and I'll get into some of that later in my decision, this deal was generated by the state, whereas you were offered to plead to 4 of these burglaries because you assisted, you helped, you showed the remorse and the empathy for the victims. But with this deal, the coverage hanging over your head was reduced from that 171 years down to 50. Still a lifetime of incarceration that can be hanging over your head. 30 years out of that 50 could be initial confinement. I am within all of my discretion to say, you know what, enough's enough. Deter everybody. Let's send everybody to prison who's going to burglarize more than 1, more than 2 places in Burnett County for the max. And it is well within my discretion to say, you know what, 30 years initial confinement, 20 years of extended supervision, and to have it done here today. To have each of the counts be consecutive, and to have it be consecutive to the Barron County case. That would be harsh. Not that, again, that it is not warranted or couldn't be warranted, but that would be harsh. Especially considering the fact that you have shown remorse. And as Mr. Schmidt has said, you may be the first defendant, at least in his practice. And he was a defense attorney, and now he's a prosecutor. But you are also the first defendant in my practice as a lawyer and as my sitting as a judge for almost 8 years to have done that, to have said, you know what, here is all of the stuff. We broke into all of these places. I want to help. I want to work. And you know what? I understand what I've done. That's true remorse. I don't know how many burglary sentencings I've had in the last month, both in Burnett County and the other counties that I sit on cases. We will go on the record in the matter 24 CF 60, State of Wisconsin versus Katie Mortenson. The state appears through Assistant District Attorney Kevin Schmidt in person. Ms. Mortenson appears in person in custody with counsel Renee Landgraf. We're set today in this matter for the sentencing portion of this case. Ms. Mortenson pled guilty on June 13th, 2024 to 3 counts of, to 1 count of burglary as of a building or a dwelling as a felony party to a crime, a 2nd count of burglary of a building as a party to a crime, and a 3rd count of burglary of a building or a dwelling and a felony as a party to a crime, and a 4th count of burglary in a building of a burglary of a building or a dwelling as a party to a crime. All other matters were dismissed and read in for purposes of sentencing. All in all, Ms. Mortenson was charged with 30 counts of criminal allegations and charges, most felonies, some as misdemeanors. None were convicted as a repeater. We're set today in the matter for the sentencing. The court ordered the pre-sentence investigation report. The court has reviewed that report, and other than some grammatical errors or spelling errors, the court did not specifically find any corrections or modifications that jumped out to the court with the court's knowledge and information. Mr. Schmidt, did you receive a copy of that report?
I did. I have no substantive corrections.
Ms. Landgraf, did you receive a copy of that report?
I did, Your Honor. My client and I reviewed it, and the additions and corrections that we have are listed in the defendant's sentencing memorandum, which was filed on the 27th in document 44 of the court file.
Thank you. Ms. Mortenson, you thoroughly went over the report, the PSI, with your attorney. Is that correct?
Yes, I did.
And did you have an opportunity to review or go over these corrections and modifications as listed in your attorney's response to the PSI and sentencing memorandum?
Yes, Your Honor.
The court has also reviewed the defendant's response to the PSI and sentencing memorandum as filed with the court and all of those accompanying documents. The court has also received and reviewed as late filings today, letters of support, character references on behalf of Ms. Mortenson. Mr. Schmidt, did you receive those copies and have you reviewed them?
I have, and I've reviewed them.
Excellent. All right. We have one victim who is going to be providing a victim impact statement to the court. I will ask that victim to come up here, have a seat at the black table, and you can either state your full name for the record and spell it, or simply just provide your initials if you wish.
My name is Jeff Washkoon.
Can you spell your last name for the record?
Washkuhn.
All right. Now you can provide your statement to the court.
How I was impacted was financially. I lost between $700 and $800 worth of stuff I had in the cabin. I'm on Social Security. It's going to take me a couple of years to get this stuff back, go buy it again. We lost personal stuff from my grandpa, other things from the cabin. Now there's 6 of us in that cabin, and I'm only listing the stuff that I lost. That doesn't include the other 5. This wasn't just a random act. It was planned out. We got a call from the sheriff's department on Sunday, and we went up to the cabin. The back door was busted in. There was piles of stuff all over the cabin. A half bowl or a half pot of chili on the stove they'd eaten there. Drank coffee there. We sealed the cabin up as best as we could. We couldn't get a door that day. We went back the next day with the door, and they'd been back and took all the piles of stuff that they had all through the cabin. The neighboring cabin, they had bagged all their stuff and put it out in the woods to come back and get later. This woman has no respect for the law or other people at all. I would like to see her get the max on what you can give her, what the courts can give her. She's been a repeater. Just no regard for anything or anybody. And I'd like to see her sentence. She'd get consecutive, not concurrent, and run this time separately from the other charges she had to deal with. I guess that's about all I got to say.
All right, thank you.
Yeah.
Mr. Schmidt, argument and sentencing recommendation, please. And for the record, the court has reviewed any and all of the victim impact statements that have been filed in the case as well.
Thank you. The PSI recommends a range of between 5 and 7.5 years initial confinement, 3 to 4 years extended supervision. They recommend it concurrent to all their cases. They're being very explicit. They want it run concurrent to another case they're clearly aware of, a Barron County possession with intent case where Ms. Mortenson recently got a sentence of 3 years initial confinement, 3 years extended supervision. So realistically, what that means is DOC gave a recommendation that if followed would, in terms of actual impact on Ms. Mortenson, result in between 2 and 4.5 more years initial confinement and between 0 and 1 more year extended supervision if the court did it concurrent. I don't know why they recommend concurrent. That's not what I'm going to be recommending. The Barron County case has really nothing to do with these burglaries. It's a possession with intent case in Barron County. When we seized their vehicle, when we searched the residence they were living at that they burglarized, there was nothing in there related to selling drugs. There's really no similarity in fact or time or circumstance with the Barron County case. And I'm not going to be doing a concurrent recommendation because I don't see why we would or how it's related at all. So I'm going to be making a consecutive recommendation. The consecutive recommendation I'm going to be making is going to be a recommendation of 2 years initial confinement, 3 years extended supervision on each burglary, concurrent to each other, consecutive to Barron. The reason I'm going to be making that recommendation, I'm going to start first by talking about where we have to start in every single sentencing, why probation is or is not appropriate. Probation makes no sense in this case because Ms. Mortenson was on probation when this happened. She had just been placed on probation for it out of Washburn County for the giving false name to avoid penalty and a theft case out of Washburn County. So the fact that this happened while on probation means we can't do probation again. It would depreciate the seriousness of the offense. Furthermore, when we look at the offender's account of why they think this happened, they trace it to their substance abuse. She complains that her current behavior is motivated by drug use. She complains that she didn't get sufficient help in the past from DOC in regards to treatment. So if the cause of the behavior is drugs and DOC has been inadequate to address it previously, it doesn't make sense to expect them to address it in the future. We follow that to its logical conclusion. If we take the defendant at their word that this was caused because I'm addicted to drugs, I can't beat my addiction on my own, and I didn't beat it with DOC, and that means treatment is necessary in a confined setting. That's where that logically has to go. It has to go to prison. So this was multiple burglaries. This was done with a co-defendant named Avery Weaver. In fact, one of the burglaries, the main residence they were living in, because they were living in one of the residences they burglarized, the police caught it. The owner went out and fixed things and started the process of cleaning up, and then they went back and burglarized the same one and went back inside. So that's a very aggravating factor. The fact it was multiple burglaries is aggravating. When we look at what they were doing, it was a little different than most other of these streak of burglaries we see. Typically, when we see people do a streak of burglaries in an area in our county, They go in, they steal the things that are the easiest to sell or fence or sell on Facebook, and then they disappear, they flee the area. These people were living in the area because part of it was motivated by poverty. That's both aggravating and mitigating, because it's somewhat mitigating because it's a cause that is, it's still criminal thinking, but it's a different type of criminal thinking than we're seeing before. It's aggravating because they didn't just go into the residences and say, you know, no one will let us stay anywhere. We don't have any money. We don't have any shelter. We need to live. Let's be careful and just take the food or the gas that we need to live. They trashed these cabins. They caused a great deal of damage. When you look at the restitution supplement, the vast majority of that restitution is not reimbursing people for missing property. It's repairing damage. And that shows a level of indifference and lack of empathy with the victims as they were committing the crimes. They weren't minimizing their footprint, they were maximizing it. She and her partner fled from police in a high-speed chase. When they were caught, police knew what their vehicle was because they had trail cams that they had set up and knew what the vehicle was. And when an officer saw it, that's when the high-speed chase began. Regardless of who was driving, once the vehicle was stopped, it was Miss Mortenson who fled from police. They had to do a manhunt where they had 2 canines and found her because of a tip from an employee at Voyager. So that again goes towards probation is not appropriate because this is a person, you know, she was on probation for giving false name to avoid penalty. She was trying to avoid penalty by fleeing the vehicle after it stopped. Probation would not make sense here. Her criminal history does reflect that going back to, I think, 2017, she's had a drug problem, specifically methamphetamine. That's been something consistent over the time she's not been able to deal with on her own. It shows that she did get convicted of a misdemeanor theft either right before or during some of these burglaries. It's kind of a gray area with the timeline of when these happened because these were cabins where people were not coming back every single day. That's how it was enabled to happen. So around that time, she didn't have like a distant theft conviction. She does have a past criminal trespass, which I have no knowledge if that was theft related, but it's kind of similar to a burglary in terms of it being at a residence you're not supposed to. So why am I recommending only 2 and 3 out instead of, you know, the victim said they want the max. The max, the court could do 30 years initial confinement on this. She could go to prison until she's an old woman. The reason why is because we accomplished something here through her actions that we don't normally get to do in serious cases that PSIs. We accomplished celerity. We accomplished alacrity. The biggest predictor of curbing recidivism is not doing the biggest sentence possible. It's doing the sentence as fast as possible, as soon after the course of conduct as possible. This was a case where Miss Mortenson was arrested and a complaint was filed in March. We had the prelim in April. Also in April, without any offers from me or from the police, she started helping the police. She told them what they did. She started helping them find the stolen property. The very next hearing was the plea hearing. There was no dawdling with statuses where, well, we want to get letters of recommendation. We want to do treatment. We want to try to, you know, get things down. The state offered 4 burglaries and they said, okay. And that's how we got here today. We got here through acceptance, true acceptance of responsibility. She's really throwing herself on the court with how they handled this and how they're going fast with this, how they're accepting responsibility with this. I sort of had an epiphany moment during this case when I was reading the reports about her helping recover the stolen property. It occurred to me, I couldn't think of a single other burglary case where someone did that. And the reason why should be obvious, but it never occurred to me before. Admitting you know where the property is probably the biggest thing you could say to assure, you know, against your interest, to show that you're guilty. Because it doesn't just show that you did the burglary. It shows that you had enough either executive decision-making in the burglary or trust by whoever did that you were allowed to know where the property was. and have some control or creative control or constructive control over the property after the burglary. That's why people don't do it. So the fact that she did that really shows to me, you know, a lot of these burglaries, there's the empathy you may have for the victim and the remorse and actually feeling bad for what you did, and there's the self-interest. In this case, we can see through her actions and what she did with the assistance and getting the property returned, the empathy overcame the self-interest, which we don't see a lot in these burglary streaks. Because the nature of these burglaries is you have to be pretty indifferent to other people's feelings and thoughts and whatnot to go into residences and steal stuff and risk encountering people.
Maybe I'm cynical, but I believe her helping and what he's describing as being remorse. I see it as completely self-serving. I think she only did it to get herself out of trouble.
Ms. Mortenson says the two motivating factors for her and why she was involved in it was one, the drugs, and two, domestic violence by Avery Weaver. I don't have any way of proving whether or not Avery Weaver was doing domestic violence or not. So I can't really say anything to that and that purpose. The drug addiction is not an explanation for it. There are plenty of people who suffer from substance abuse who don't. That's not a reasonable explanation for the behavior at all. So when I look at the totality of the things, the 2 years initial confinement, 3 years extended supervision, I think accomplishes the purposes of specific deterrence while also appreciating what I think is genuine remorse and the ability to actually have made the victims whole with their own property rather than money that they'd have to spend getting something similar, but not quite what I had before. That's something that really is of high value and of high merit. I think it accomplishes general deterrence objectives too, because it's significant enough to send the message to the community. You get prison for burglaries. That's an important message to send. A Burnett County resident is 3 times more likely to be a victim of a burglary than a Wisconsin resident on the whole. We need to address burglaries in our county and prisons the way to do it, through general deterrence. It accomplishes incapacitation as well to some degree, because the totality of it will be, run consecutive to the Barron case. She's going to be in prison for 5 years. And then she'll be on extended supervision for 6 years after that. So there's a lot of time over her head if she doesn't curb things, if she doesn't take substance abuse treatment seriously. She doesn't sever ties with Avery Weaver for her to go back to prison for another up to 6 years. Because we know if DOC revokes on cases, they'll often revoke on all cases if it's a severe enough violation. So she could face all of that for a single violation on probation for both of them. That's the reason why I'm making the recommendation I am. Thank you.
Thank you. And before I begin, at the last hearing, we did have a stipulation to $13,137.29 in restitution. That's still the case here today, correct?
Yes, Your Honor.
And that is from you, Ms. Mortenson?
Yes, Your Honor.
All right.
Joint and several with Avery Weaver.
Correct.
Yeah.
Joint and several with Avery Weaver. All right. And so I'm going to ask first, Ms. Landgraf, for you to provide your argument and your sentencing recommendation. Again, I have read and reviewed the information you filed. If Ms. Mortenson is going to provide a statement, and I did read that she has a written statement, or at least she told the PSI author that, I'm going to advise that she do so slowly, enunciate your words. And I know that this is emotional, and I can see it's emotional on you, but it's very difficult for a court reporter to be able to understand if we're hearing with tears and those types of things. So I'm not saying don't cry. I'm not saying don't show emotion. Just be cognizant of that when you're providing your statement so that we can make sure that everything is heard and taken down, okay? And then Ms. Landgraf, if she is going to provide a statement, please make sure that the microphone is back towards her so that the visiting court reporter can adequately hear. Ms. Landgraf.
Thank you, Your Honor. I did put my recommendation and reasons why in the defense sentencing memorandum, so I don't want to take time to rehash all of that. But in sum, I am recommending 4 years initial confinement, followed by 4 years extended supervision, but concurrent to the Barron County case. I completely understand the state's argument for consecutive time, and I really don't think that the defense and the state are too far off as far as how much time she should actually spend in prison. 4 years. With the state's recommendation, she would have initial confinement for 5 years. With the defense's recommendation, she would have initial confinement for 4 years. The reason we're asking for a longer initial confinement and it concurrent to Barron County is to ensure that she gets the programming in prison that she so desperately needs. And one of the main reasons why probation is not adequate in this case. She was sentenced to prison in Barron County. She had 88 days credit. So she has a little over 2.5 years to serve on that sentence. She cannot take advantage of substance abuse treatment if she has an open pending case. So she has another open pending case in Barron County that she hopes to resolve soon, but we don't know how long that's actually going to take. So until that is complete, and then she has to have enough time on her sentence remaining in order to actually go into the program and complete the program. I think the worst thing here would be to send her to prison and then she doesn't get the substance abuse program. This will be her first time ever going to prison. So I think it's necessary that she able to get that program. So I understand, and I understand that this court typically does run as sentences consecutive to other crimes, but given the treatment needs here and also that she is serving Barron County on a methamphetamine charge, and methamphetamine, I do believe, was the main driver of the.
Again, I want to interrupt simply because it's not just a methamphetamine charge. It was intent to deliver methamphetamine. It was a large amount of methamphetamine, if I'm recalling correctly, over 12 grams.
11.
Oh, well, okay, 11 grams. Still a lot of methamphetamine.
Correct. And she did cooperate with law enforcement over there that resulted in several other arrests. I believe that the case there, and I think the prosecutor made the argument that her intent to deliver was to fund her own addiction and not to make money. And I think that's pretty clear with how she was living when these incidences were occurring. She doesn't have a history of having large quantities or having any other dismissed and read in cases or even been arrested for possession with intent. So I do understand the concern of the court that it's possession with intent is the charge, but I think all the parties in that case, and I did watch that sentencing hearing by Zoom. I believe that she was self-funding, and I think that's probably why Judge Boyle gave her 3 and 3 instead of a much higher prison sentence, which is not uncommon in Barron County to have a very harsh prison sentence for possession with intent. But again, I do think the state's recommendation is reasonable, and I do think it's appropriate. It's very close to what the defense's recommendation is. I just want to ensure that she's going to be able to get the treatment that she needs, because that will not only help her and her family, but also the community.
All right, thank you. Ms. Mortenson, I'm now going to turn it over to you to provide any statement you wish to the court to let me know anything that you want me to know or to consider to inform the court of if you've heard anything stated either inaccurately or not as strongly as you wish by either the state or by your attorney. Do you wish to make a statement here today?
I just have an apology letter.
All right. And again, please make sure that you speak clearly into the microphone so that we can ensure that it's all taken down.
Okay. Okay. the people I victimized. I know I hurt you, and I can understand why it may be hard to forgive me. I want us to be okay with each other. I hope you can forgive me. In the meantime, I will pray for you and do my best to repair the damages I caused. With God's help, I will work to overcome my problems. If there's anything else I can do, please let me know.
All right, thank you. And before I begin with any type of sentencing, in your sentencing recommendation or memorandum, Ms. Landgraf, you did request that it be a different conjunction of sentences. But I can tell you that your remorse, your tears here that you're showing here today are real. I can tell real versus fake. I can tell remorse of, oh, poor me, I'm going to prison now, poor me, versus I feel bad for me, I feel bad for my family, I feel bad for my kids, and I feel bad for the harm I've caused and the victims I've created. I see true remorse. Mr. Schmidt is exactly correct and right, and your attorney didn't necessarily say that she agrees, but in her recommendation, you can see that she agrees. This is not and could not ever be a probation case. Because the court would have to look at first needing to determine if the public is needed to be protected from you from further criminal conduct. And right now you are in this place. You've had time to sit while you're incarcerated, to get clear-minded and to be clear thinking, to sit and say, oh my gosh, what the heck did I do? That was terrible and that is awful. However, you're still not yet in a place where you can be sober, drug-free, and that clear thinking and minded, where I can be assured that the public is protected. You need confinement, and the public needs you to be confined. Because if I look at your previous sentences, sentences for your convictions, and your previous CHIPS case, you did well and you did become sober, but you didn't utilize the treatment and the treatment services in the community. You did for here and there and a little bit to get your kids back and to do what you needed to do, but not enough to have it be fully instilled in you for you to continue to take charge of your sobriety and take charge of your life.
Oh, so you mean it was sporadic and self-serving? Gotcha.
And I'm not saying that you can't do it, because I believe, especially seeing this remorse and seeing this personal reflection, that you can do it. You are in a place you want to do it, but right now the community is not an option. And so that's where we get to, you need treatment. Only a correctional institution can provide right now. And yes, she does. You're shaking your head, no, sister, but yes, she does. I see cases every single day. These attorneys see cases every single day. She does. And she will. She's going to prison right now for Barron County case. And if I were to put you on probation, even to do it consecutive to the Barron County case, that would unduly depreciate the seriousness of this crime spree, of the actions that you have done, the conduct that you have engaged in, and your behavior. Because the court has to look not only at you and if you have the ability to rehabilitate. I need to look at the fact of the victims, and I need to look at other things as it relates to that, such as I need to look at if there's any undesirable behavior patterns. This appears to be your first burglary spree, and whether or not it was facilitated or a factor was your substance abuse in addition to domestic violence. In the end, You had the choice to do that. You had the choice to do that. I know domestic violence very well. I practiced as a domestic violence attorney, representing domestic violence victims. I understand it completely. And I understand the stress you may have been under and the anxiety you may have had and the fear you may have had while involved in that relationship. And I do understand that sometimes people feel there's no way out. But when we look at the law and we look at violating the law and we look at the repercussions from that, it still comes down to your choice. Many domestic violence victims in similar situations are not, they don't make the choice to break into multiple people's homes and or cabins. And you did that time after time after time. And I understand your excuse that you've provided about the fact, and it came through in one of your character letters that you may have been told that it was well, first you said it was an uncle's cabin, one of them, and then you may have been told by Mr. Weaver that it was his friend's cabin. But something in your gut had to say this isn't true. If we have to take a hammer, a crowbar, something to break into those buildings, and we're actually taking things from them, that's not true. And so if you're telling yourself and you're trying to tell the world that you did believe that those cabins were friends of Mr. Weaver's and he had the permission to take those things, if you truly thought that, then you're lying to yourself. I don't believe you believed that. And you're shaking your head no. That's just an excuse. So we're here for the accountability factor. And as I said, you did admit and you are taking the responsibility and you're saying, you know what, judge, you know what, victims, I'm ready to be accountable. I understand you have 3 unbelievably beautiful children that are really, truly victims in this matter too. And I did read the letters that did request and did plea to the court to allow you to come home as soon as practically possible because your mom's raising them. She's not in good health. And the court can't look at it like that. I can't say, okay, criminal defendant who has hurt and victimized many people, damaged a lot of properties, it's okay because you have kids and you have to raise them. I can't excuse this behavior and say just because you have kids and they need you because they do, that it's okay. They do need you, Miss Mortenson. And they need you to be sober. They need you to be present. They need you to engage. They need you to help them with their homework. They need you to help them learn to count and to learn the colors and their shapes. And as much as it's going to be difficult in prison to be a parent, it can still happen and you can still do it. And I've seen it. And I've seen relationships actually grow and prosper with parents in prison and children that get to visit by video or telephone and send the letters and do the things. Because if you're going to go to prison, and you are in Barron for sure, it's your decision and your choice how you're going to respond and react and what you're going to do from here on out. And I know that a lot of blame wants to be put on Mr. Weaver. He's probably he is the most culpable. He is the mastermind. But at every juncture, at every point, you had choice. We have domestic violence shelters all over, and in particular, I believe it's Shell Lake, they have one, or they have 2. There's one in Milltown. There's a satellite office here in Siren, there's help. I don't think you are a bad person. I think you've done a lot of bad things. And now you're going to have more felonies on top of the other felony convictions that you have had. And you're going to have to carry that for the rest of your life. Burglaries are classified as a violent crime. And sometimes, or a lot of times, criminals don't think of that. They don't think that, they don't realize that they are. Because at each and every place that you broke into, there could have been someone there. There could have been someone who was triggered to go there. A death or substantial injury or anything in between could have occurred and could have happened. You were breaking into somebody's cabin, because I believe they were all cabins here. We're breaking into their sanctuary, their haven. And you took away more than just property. You took away more than just financial aspects with the damage that you've caused. You took away a sense of peace, a sense of tranquility. You instilled fear that someone will come back, that they'll never be safe, their stuff will never be protected, and that they have to constantly be vigilant and watch out. And that's another sad part here in these types of cases, because as much as I am to focus on you and rehabilitating, and you can heal and you can learn and you can take control of your life and you can never do this again, I can't give all of the peace back to the victims. I can't ever make them whole. Even if I had all of the money in restitution and I gave it all back and I gave all of their property back, I don't have that magic wand to go zippity-doo and they're better. And as we specifically heard by JW here today, that this is particularly hurting him because he's on Social Security and he's on a very fixed income and he's not going to be able to replace his property or provide his share of the money for the damages and all of this for this shared cabin. And so it hits victims harder than others in different ways. I really want to see you succeed, Ms. Mortenson, and I want to see you do so much better, because I think you can. Even though I did read in the PSI that when you were in high school, you were having issues and you were having problems. I'm going to tell you that I don't know, because I don't have your records. I don't have any tests or anything to let me know your intellectual level. But the way you have been portraying yourself from day one of the arrest until now, not at the time of the arrest because you fled and you tried to flee and you were not being very cooperative, but from the date of the time that you were arrested, after there was that quiet settle down time until now, you have presented that you have a good understanding of life and that you are a smart individual and you can figure it out. And quite honestly, on the top of my head, I can't recall if you did get your HSED. You have goals of getting your HSED. I think that is definitely something you can accomplish. And I want to see you accomplish that. Because just in reading the letters that fully support you and in hearing you and through the PSI and through your statement and through your attorney, you want a better life. and you want to provide that to your kids, and it sounds like the father hasn't been involved hardly at all to be able to do that. So in hearing all of the arguments here today and in reading all of the information that has been presented, now I'm going to tell you what your fate is. I do have to correct Ms. Landgraf, though. This court doesn't always do consecutive. There are times when concurrent, even when they're separate cases, separate crimes, separate counties, concurrent is the most appropriate. But here, it's not appropriate. Because we have separate cases, we have completely separate crimes, completely separate times, separate people, and separate counties. There is absolutely no similarity in the time or in the fact. And as Mr. Schmidt stated, there was no evidence presented or found at the scenes or on you to believe that there were similar methamphetamine intent kind of things. And again, I understand the argument with regards to the intent to deliver methamphetamine for the Barron County case. 11 grams of methamphetamine is a lot. And it is more difficult to get that amount in quantity unless you have a larger sum of money and you know the right dealer. And usually dealers that deal like that deal so others can deal, so they can make the money to support their habit. It is. Even though it could be an argument that you had that quantity for you and Mr. Avery, there's also the counter argument that you had it and you could sell it and you can make the money to support your habit. And that is a serious crime. I don't think these crimes have to define you. I think you can build yourself up and you can be better. But for this moment, this is about the punishment factor, because you do need to be punished. You were punished in Barron for that, and you're going to be punished here for this. With regards to these cases, I was kind of swinging back and forth in my head, various things to do throughout and what to do with regards to the Barron case, because they happen so closely. And I do know you will be sitting at least 3 years in initial confinement and 3 years of extended supervision for that case. So and I was considering or thinking about having consecutive sentences for each of these counts or for some of these counts together, because again, different days, different times, different victims, even though it may have been one spree of crime. But it doesn't just affect the victims all at once, because each of them were affected differently at different times. And each time you had the ability to stop and to think or to tell, to run to law enforcement and to tell. But you didn't do that. I do want to see you get the substance abuse treatment if you wish in prison. Or quite honestly, I'd love to see you do the challenge incarceration program, because that is my favorite. And you need to have at least 36 months remaining on your sentence to be able to get into those programs. And even though you will be sitting time in Barron, for Barron's case, you would still be able to engage in programming, just not the programming to be released early. Because again, there needs to be that punishment component. So with regards to 24 CF 60, counts 1, 3, 5, and 9. What the court is going to do is I am going to sentence you to 3 years of initial confinement, 3 years of extended supervision, and again, that's consecutive to Barron County case. That gives you an opportunity to sit your Barron County matters and then be immediately eligible to engage in programming to have an early release. You will be eligible for substance abuse programming as well as challenge incarceration programming. This is consecutive, so you get 0 days of jail credit for this sentence.
Oh, Judge,
But she's not on probation. She wasn't on revoked or anything. How much jail credit does she
I don't
get?
know about that, but she's been in our jail on the cash bond for 181 days.
But when was she sentenced in Barron?
August 2nd.
I don't think they use that credit. Because their credit
No,
was way
they
lower
don't use
than
that
us.
credit, but she doesn't get credit from August 2nd on.
Correct.
Oh,
Correct. She was on probation during this incident and she is being revoked, but she has not been sentenced on those yet. So she has not received credit. So I believe that she would get 151 days credit. I did put that in my memorandum too, from the day she was on a cash bond until the day before sentencing in Barron County.
So you said 151 days?
That's what I calculated.
I'll put 151 days of credit. This is also going to be consecutive to any other sentence that you shall receive. Because again, you were on probation. You literally got on probation on December 5th, 2023. And then you went out and engaged in the first offense on December 24th, 2023, and followed thereafter. If I said February, no, it was November. The first one I believe was in November. And then you were placed on probation on December 5th, and then December 24th, you broke in and did stuff again and victimized. So it needs to be consecutive to any and all sentences, whether or not your probation revocation is concurrent with the Barron, I'll leave that to them. But this sentence is consecutive to all other sentences. On extended supervision, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no contact with Avery Weaver. I'm ordering that you participate and cooperate with the state in Avery Weaver's case. That you have no contact with anyone on any felony extended supervision or probation unless approved by your agent. No casinos, no establishments that have the primary purpose for the sale or the service of alcohol. You need me to go slower, I'm sorry. Gainful employment. Get your HSED or equivalent. And gainful employment would be gainful employment or continued education. A parenting class. Mental health evaluation and follow through focused on trauma and domestic violence related matters. The Thinking for Change or Breaking Barriers program while incarcerated. No contact with victims, their residences, or their cabins. I'm ordering you to provide your DNA. I don't believe that these are crimes that you would be able to get your DNA expunged, but if you wish to request that, you can write a letter to the Department of Justice. It's their discretion on whether or not they do so. $518 in fines and fees per felony count. $13,137.29 in restitution, joint and severally liable with Avery Weaver. No use or possession of a firearm for life, no voting in any election until your civil rights are restored. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your restitution or your court costs and fees, the court will enter a civil judgment against you. You're always going to owe it, and you could sit up to 6 months in jail per count. Concurrent on the counts, consecutive to all other sentences. Mr. Schmidt, what is the state or what is the court forgetting?
Nothing for me.
Ms. Landgraf?
I don't believe there's anything missing.
Ms. Mortenson, I see a lot of people in front of me. I do, and the state sees a lot of people in their cases as well. It's very true that when I say, as well as Mr. Schmidt has said, we don't see many people who truly, truly have remorse and who have empathy for the victims that they have caused. I do think that you are a good person. I think you have a good heart. I think you went down the wrong path with the wrong people. And I think somebody else, either your mother or somebody else in the PSI, did state that. And I do understand your trauma, and I'll tell you that what happened to you when you were a child. And that's specifically why one of the reasons, along with the domestic violence, that I ordered that mental health assessment focused on trauma. Because I think you have a lot of things you have to work through and a lot of things you have to heal. And what happened to you is not your fault. But how you conduct yourself and how you create your life is your fault and is your choice. And so I think you want to do better, and I can see that you want to do better, and I truly hope you do. Okay?
Okay.
All right. Anything further?
No.
All right, then we are adjourned. Thank you.
I didn't want to talk a whole lot through that one because that was kind of a learning one. I really do like that judge. She has a lot of empathy for people. She knows what to say to put them in their place without putting them down. And I don't know if that has an impact on their lives after sentencing, but I would certainly think it would. I'm not sure, but I really do like her as a human being and as a person. She seems like a wonderful human. I wish, it was 3 years in confinement with 3 years on probation, and it was to run after the Barron County case, because the judge wanted to make sure that she was eligible for the challenge program, which has a lot of courses involved with it, and also does like a rehabilitation thing and gets them ready for reentry into society, and also allows for some form of early release. It's Earl Grey's birthday. And if you go look on the community page, yeah, well, you know what? Here. I'm just going to show this. I'm going to show this. All right, give me just a second. I got to pull it up. Bear with me. It's worth it. All right, I said today is a very special day. I received this from Earl Grey's birth grandma. I couldn't say it better or cuter. Look at the baby Earl. Oh my goodness. He's so cute. I just love him. Look at the cute little pink nose. He's so wonderful. Yes. Oh my goodness. He was, I bet she could have held him in her palm. All right, guys. Yes, I will clip that one into a replay crew mini. That way everybody can give that one a good rewatch because there's a lot of information. There's a lot of detail. I understand it is, somewhat difficult to follow, but yeah, it's when you do have to pay attention for, but it's worth it. It's worth it. And again, sorry for the 2 cases that I can't replay crew mini because of the technical difficulties. Sorry. Only one was my fault. Be safe, be well, sleep sweet, and much love.